Hello everyone, this is Pammy Jaiswal. Today, I'm going to briefly discuss with all of you on a very recent consultation paper which SEBI has brought on 18th of May 2023. Now, what this consultation paper deals with? This consultation paper deals with reviewing the definition of unpublished price-sensitive information. Now, unpublished price-sensitive information is actually relevant when we talk about the insider trading regulations, right? But it also has other relevance at other places. So first, let's understand what is the proposal. The proposal is to include the reference of material events under Regulation 30 of the LODR under the definition of UPSI. So this was the exact reference which was omitted by the amendment made in 2018, where SEBI felt that all the material events under Regulation 30 are not in the nature of UPSI. But on a particular study made by SEBI, it has now made a proposal to re-include this reference. So let's understand what is the difference, or whether there is a difference between UPSI and a material event under Regulation 30. So what happens when we determine or when we ascertain that a particular piece of information is UPSI? When we ascertain a particular piece of information is UPSI, we say that this information has to be, first, that you're sharing this information. When you share the UPSI after its germination with anyone, you need to make entry in the SDD. You will not be disclosing that UPSI to anyone other than for legitimate purposes of business till it is made generally available. And in fact, your trading window closure requirements would also start for your designated persons. So this is primarily the three things that happen when you ascertain a particular piece of information is UPSI, right? But when a material event under Regulation 30 takes place, what do? You promptly disclose the same to the stock exchanges, right? So once you have any event under Regulation 30 taking place in your entity, the same needs to be disclosed to the stock exchanges. So there lies the difference. When we say that a UPSI has germinated, till the time it develops and becomes a material event, it needs disclosure, prompt disclosure to the exchange. But during this developmental phase, when it is developing, when it is concretizing, that actually this is going to happen, right? This is going to be formalized by way of, let's say, entering into the agreements or taking requisite approvals at the board level, at the company level. So then it has to be disclosed to the exchange. But when UPSI is germinated, when UPSI is, which comes into existence, then your compliances start from the very point when the UPSI germinates, right? So this reference, which SEBI now proposes to insert under the definition of UPSI, would have several consequences. So first, let's understand, let's just take a look briefly at what the list under Regulation 30, read with Schedule 3 of the LODR, contains. So Schedule 3, or the list which is coming under Part A, Para B, and Para C. These are the three broad categories under Part A of Schedule 3, which is to be read with Regulation 30. And they contain the list of events and information that are required to be disclosed to the exchange. So what is the difference between the three? When we talk about the information under Part A, Para A of Schedule 3, we are talking about deemed material events. That means irrespective, once this information, once the event under the given list has taken place in your entity, you will have to disclose to the exchange. There is no discretion that needs to be exercised when it comes to the items under Part A, Para A of Schedule 3. So you will look at the list, you will find that there are several such items which are actually in the nature of UPSI, right? For example, declaration of dividends, acquisitions, coming out with any specific capital issuance, etc. Now, you will also find that there are certain list of items under Part A, Para A, which are of informational relevance. So primarily, if you look at the list given under Schedule 3, Part A, Para B, Para A, it contains such information which has informational relevance. It has an informational content, and therefore it is relevant for the shareholders and stakeholders to know about it as and when that event takes place. But does that mean that every information under the list is in the nature of UPSI? The answer should be negative, because if you look at information like appointment or discontinuation of share transfer agent, let's say you look at the proceedings of AGM or EOGM, you look at the issuances of notices, call letters, etc. Now, these information, they are relevant, but they are carrying an informational relevance. They do not have the potential to cause a significant or a material price variation in the scrip prices. And that is where the difference from UPSI perspective comes in. When I say that an event in information is UPSI, I'm saying that information has the potential to cause significant price movements in the scrip prices. But that's not the case with each and every item given under Schedule 3, Part A, Para A, right? So here we need to understand that there is a difference between calling an information or ascertaining an information as UPSI versus deeming it to be a material event. And here, if we again move to the events and information given under Part A, Para B. So Part A, Para B of Schedule 3 contains such list of items which are not in the nature of deemed material events. That means what? Whenever these items take place, you will have to test them for materiality. And at this stage, I would like to just mention that SEBI in its board meeting dated 29th of March 2023 has already approved the proposed changes to Schedule 3 and Regulation 30. And pursuant to that, quantitative thresholds for testing materiality has been introduced. While the same is not in operation as on date, but sooner or later, this is going to come into operations. So for Part A, Para B items, you will have to test if these items are fulfilling the thresholds of materiality. And if yes, they are, then they are material events and they require disclosure to the exchange. Now, there is also Part A, Para C, which is kind of a residuary clause and contains or gives the discretion to the management to decide any other information except for Part A and Para A and Para B items, which could be in the nature of a material event. So, if we look at the definition of UPSI, the definition of UPSI reads unpublished price sensitive information means any information. So it is an exhaustive definition complemented by an illustrative list of UPSI items. So apart from the illustrative list of items given under the definition of UPSI, there cannot be a case of a deemed UPSI. Because if I say that any event under Regulation 30 is a deemed UPSI, we are actually frustrating the intent of calling an information a UPSI, right? So why was SEBI forced to make this change? Because SEBI, when it omitted the reference in 2018, it did so with the intent that companies would exercise their own judgment, their own discretion, and they would accordingly comply with the provisions in spirit. But what it actually found was that even major events that are taking place in the companies, like, any major investments, any larger deals won by the companies, and they are such which can cause significant price movements, are not being classified as UPSI. So by taking a shield of not categorizing a particular piece of information as UPSI, SEBI found that there is no uniform practice by companies, and it is actually causing a hindrance when it tries to probe into the insider trading cases. And it found on its study on certain press releases from January 21 to September 2022 that out of 1,099 press releases, there were 227 press releases which contained information which could actually cause a price movement of more than 2%. But to the surprise of SEBI, it found that only 18 cases out of 227 cases were categorized as UPSI, and the rest were not. So looking at this current practice, SEBI thought that it is wise to re-include the reference of material events under Regulation 30 of LODR under the definition of UPSI. So having said that, I would also like to mention that for debt listed companies, they will be continued to be guided by their current practice, because the reference which SEBI intends to include in the definition is material events in accordance with Regulation 30. And Regulation 30 is not applicable on debt listed companies. So before coming to the suggestions, let's understand what are the potential consequences. As we discussed earlier, when an information is categorized as UPSI, you will have to comply with certain compliances. Now, what are the compliances? Now, once Regulation 30 gets amended along with Schedule 3, you will have a long list, even a longer list under Schedule 3, which has to be considered as UPSI. And once a UPSI has been said to be in existence, you will have to make entry in your structured digital database, which is SDD. Not only that, but you'll also have to close your trading window. And then again, you will have to follow the other compliances. So what could be the way out? Now, instead of simply referring to the material events in accordance with Regulation 30 under LODR, SEBI may consider a suggestion where germination of UPSI for events or information enlisted under Part A, Para A and Para B of Schedule 3, which have been tested for materiality and have been found to be material, should be inserted. Which means that the list of items under Part A, Para A and Part A, Para B, if they are tested for materiality, and they pass the test of materiality, either at the inception when the event starts taking place, or the concrete discussions or the formalization starts taking place, and they fulfill the test of materiality, or when that event actually passes, when the event actually happens and it passes the thresholds of materiality, should be regarded as UPSI. The last date for giving comments on this is 2nd of June 2023 on a particular email ID, and as per certain instructions which SEBI has given to all the stakeholders. So with this, I'll thank all of you for your patient listening, and thank you so much.